Yes.
May it please your lordship. Well, it's just reflect on one issue that I want to raise. Have your lordships ever heard for the president withholding a bill?
Sorry?
Since independence, have your lordships ever heard of the president withholding the bill?
I think there was one occasion during one president's period.
That was for some other reason.
Maybe, but there was.
Yeah, but
I recollect in my memory.
Yes, I'm aware of that particular, but that was with another intent altogether. But be that as it may, Malas, what's the reason for that? Let's just, because the parliament is sovereign.
Will of the people.
Will of the people. Parliament is sovereign. Executive cannot. And this president, a president is an elected president. Even then, because there's an element of urgency, the will of the people has to be implemented immediately. And if the president doesn't exercise that leeway, in what circumstances should the governor exercise it? He's only an elected, he's not elected. Now, the other constitutional issue. Mullahs, when it, sorry, Mullahs.
Yes.
The other issue is when the bill becomes law, there is a presumption of constitutionality.
Yes.
Presumption.
Always a presumption about it.
Always a presumption of constitutionality.
And the burden is on who challenges it. And
Correct.
it's a very
Correct.
strong burden.
Correct. Now, I explained to your lordships how actually a bill comes into being yesterday when I elaborated the manner in which the law ministries, all these aspects are looked at before a bill is introduced. And the legislation is not concerned with the constitutionality of the bill. That's the domain of your lordships. In fact, these questions are raised in Parliament several times. And some of our members say, but this bill is unconstitutional because
According to you, the legislative competence of the bill cannot be examined by the governor.
Exactly. Cannot be. That's why this bogey of timelines and all that is not necessary.
Because the written constitution is lost if we take that position.
No, I'll tell your lordships what that position is. I'm just explaining at the moment, Mullahs, that as far as the legislation is concerned, the parliament, when it passes a bill, being a sovereign authority, is not looking at its constitutionality. Several times, Mullahs, we pass a bill. Ultimately, it may be provisions are struck down by this court. Sometimes the legislation itself is struck down. But at the stage of introducing it and passing it, we don't test it. Right? So if we don't test it, Mullahs, what are the three grounds on which you can test constitutionality? Just look at it from constitutional principles. Number one, will the president say, in case it's a bill introduced in parliament, that you are entrenching upon a power of the state in list 2? That's the 254 issue. Will he send it back on that ground? That's one area of testing constitutionality. 2, will he say you are violating a fundamental right of citizens? That's 2. 3, you don't have capacity. These are only 3 grounds, Mullahs, on which a legislation can be challenged. There is no 4th ground. All this will be challenged in a court of law by citizens or by somebody else. So it's in the rarest of rare cases, Mullahs, that a governor will say, no, I cannot decide it for whatever reason. Supposing, Mullahs, in a state university, the chancellor is the governor. Just to give an example. And Mullahs, a legislation is passed that the chancellor should not be the governor. what possibility will he have to clear this legislation? Supposing in a state there is an issue of private money lenders are charging an interest of 30–40%. And the state wants to pass a legislation, no, this shouldn't be done. It should not be more than 12%. Fundamental question is, what is that leeway? And if you give that power, sorry.
Makes the law relating to shipping, any number of entries in the.
That's right, that's capacity violation of constitutional provision. I'm not disputing that, Mullahs. But will the president raise it, or will it allow to be raised in a court of law? Because, Mullahs, at that stage, this issue is not to be considered as a matter of constitutional law. The remedies are available under the Constitution. If it's remediless, I can understand. Because it will result in a quagmire, Mullahs.
But suppose if we find that the legislation is repugnant to any central legislation, can it not reserve for the opinion of the president?
Mullahs, normally, Mullahs, there's the constitutionality of the presumption of constitutionality. Normally, no. That will apply to a bill also. It's been passed in the legislature.
No, but
it's a rare case. It'll be a rare case.
it's a rare case, but some like my Justice Narasimha give an example. If the state legislature passes a bill or legislative law on the subject of shipping,
In the area of shipping.
Citizenship, take any number.
Let's assume, Mullahs, first of all, your lordship, these fact situations are never before the court. Mullahs, the point is, you are now taking an example that has never happened in the history of of the Republic of India, and testing the proposition on the basis of 200 and 201.
Therefore, the question that we are putting is whether in such a case, can the governor not exercise his first option or second option?
It's in the rarest of rare cases, Mullahs. I'm saying that has never happened before. We are now assuming something that Mullahs, legislations are not passed like this, or not, bills are not introduced like this. Mullahs, supposing there is a price regulation in respect of drugs, Mullahs, how these bills are not introduced? You will ask the Ministry of Health what's the impact of it on the consumer. You will ask the Ministry of Consumer Affairs what's going to be the impact. You will ask whether under the drug control order you can do it or not. Should you do it? Should you do it with an essential drug? Should you do it with another drug? Then it goes to the Ministry of Law. These legislations are not passed on the ipsic dixit of ministers, Mullahs. Therefore, I understand what my lord is saying, but it's never happened.
Therefore, Mr. Sibal, even according to you, the governor will have to apply his mind at least to find out whether the proposed bill is within the constitutional framework or not.
Well, the problem is, I'm sorry.
Two expressions which I am again repeating, shall declare presupposes application of mind by the governor. And that application of mind, we can, of course, you can argue that what will be the contours of that application.
Yes.
The other side can also argue what should be.
Correct.
So within that framework, neither he can be treated as a postman, nor he can be a super legislative power to take over.
Absolutely. No, your lordship is right.
Legislative assembly.
Your lordship, in fact, asked that question and said that I would address it, Mullahs. Now, let me address it straight away. Mullahs, the bill is sent to him. He doesn't have a formal declaration to be made. He assents to it. His assent is a declaration. Right, Mullahs? There has to be no formal declaration. Two.
Grant of an assent is a declaration.
It's a declaration. That's right. So there's no formal declaration, right? Two, he sends it back. Let's say he sends it back. It's a declaration. It's a declaration that he's sending it back, and he's withholding assent. They go hand in hand.
If he sends to presidential assent, again it's a declaration.
That's right. Therefore, and it is withholding. Kindly note the word. Withholding assent is coterminous with his sending it to the legislature and sending it to the president.
What gets excluded is only a pocket veto.
That's correct. Correct. It's completely excluded. Now, the question that what my lord asked, so declaration is clear, my lords, it is the act of the governor to, which itself is a declaration. There is no formal declaration to be made, right? What your lordships are looking at, what are the contours of that? Namely, supposing he starts giving reasons, that this, for this reason, I am sending it back to you. Let's assume, my lords. Are those reasons justiciable? Parliament, the state legislature will say, we don't agree. The end of the matter. Even if he has reasons. He'll have to pass it. If it sends it to the president, Malas, and the president sends it back with the same, and still the legislature passes it, it'll have to be passed. So, Malas, the process is what's important. The sovereignty of the, sovereignty of the legislature is as significant as the sovereignty of parliament. And supposing all these, I'm sorry.
Assigned to them.
That's right. Otherwise, it'll be a violation of separation of powers. So he can do that. So the question is, how soon should he do that? That's ultimately we boil down to that. He can do that, but how soon should he do that? The president does it forthwith, never delays it. Should the governor be allowed to delay it? That's the question. Right? Malas, the home cannot function unless there is marital accord, Malas. That equally applies to institutions. You can't create a discord. The marriage will break down. The constitutional machinery will break down. And the court must attempt to ensure there is no area of discord. So there the key words are as soon as possible. It was not later than 6 weeks. They said no, which means forthwith. Immediacy, element of immediacy. Why? The will of the people. Why should people have to wait if the rate of interest charged by money lenders is going to be 50%? Why should fishermen wait if the law is to be regulated as far as fisheries are concerned? Why should that wait? What's the reason? And the governor cannot say, I had no time. Well, there will be extraordinary situations, which is why it is very dangerous to lay down laws without context. This is a very dangerous area. Because then you give examples which are not before you. And then you test those examples on the basis of constitutionality. And those examples may be completely unrelated to reality. So you're given a situation where an argument is being made, give that discretion. Of course, the argument is extreme. He says, if I don't decide a bill for 3 years, it doesn't matter, or 5 years, it doesn't matter, because it is not justiciable. Constitutionalism has to be worked out.
No, the argument is that the governor has the power to permanently withhold it.
That's correct. So that's one extreme argument. If your lordships don't agree with that, we still have to find contours within which it must work, Malas. The Constitution must work in a manner that is consistent with the parameters set out in the context of separation of powers and the primacy of the legislature. So, Malas, that's what I wanted to place before you, Malas, before I move on, Malas. Would my lords be, Malas, you'll have to do me a favor, because now it is volume 2.5 and not 2.4, Malas. Because I've incorporated, yeah, yes.
This is the latest.
Yes, I'm sorry. My mistake. Now, Malas, I'll just cite 2 judgments on. I hope, Malas, when it comes to writing a judgment, the wrong volume is not given to you.
Eight ninety-six. We can discard this.
Yes, please, 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 please.
So, Nihal, Lalu.
Discard that, please. The previous one also. There's a previous one which I did in the beginning, Malas. That also needs to be discarded. So, Malas, kindly come to Malas, volume 4, volume 2.5, page 893 and item 4, this judgment, NCT versus Union of India. Malas, just a couple of paragraphs. Yeah. I mean, I can understand the situation. There is a tsunami, whereas the state is, everybody is dealing with the tragedy that has happened 2 months past, 3 months, no problem. Malas.
Serious law and order situation.
Correct. Look what's happening in Himachal today. Look what's happening in Jammu Kashmir. Punjab, Malas. Punjab is totally inundated. See what's happening in Himachal. You see the timber that's coming down. It's just, one wants to cry as to what's happening in our country. Now, in that situation, Malas, there's maybe a delay.
Is appearing for Himachal today.
Yeah. So volume 36, PDF 103, page 13824.
13824.
Yes. And para 142 and 143. PDF page 103, Malas. It's easier to get that. 5.36, PDF 103. And paragraph 142. It'll take you directly to that paragraph.
Page 13.
13824. Para 142. PDF 103. Michael. The room, I'm sorry, Malas.
Yes.
The room for discretion while interpreting constitutional provisions allows freedom to the judges to come up with a formula which is in consonance with the constitutional precepts while simultaneously resolving the conflict in issue. The following observations in Bomai say, constitutional adjudication is like no other decision-making. There is a moral dimension to every major constitutional case. The language of the text is not necessarily a controlling factor. This is what my Lord Justice Narasimha put to me. Is not a controlling factor. Our Constitution works because of its generalities and because of the good sense of the judges when interpreting it. It is that informed freedom of action of the judges that helps to preserve and protect our basic document of governance. It is imperative that judges must remain alive to the idea that the Constitution is never intended to be a rigid and inflexible document, and the concepts contained therein are to evolve over time as per the needs and demands of the situation. Although the rules of statutory interpretation can serve as a guide, yet constitutional courts should not, for the sake of strict compliance to these principles, forget that when the controversy in question arises out of a constitutional provision, their primary responsibility is to work out a solution, which is what I was mentioning to your lordships at the outset. Now come to Madh's page. This is PDF 1307.
Whose opinion is this, Mr. Sipa?
Give this position.
No. What is quoted of?
Justice Bomai, in Bomai.
Even ready.
Deepak, no,
No,
in Bomai.
Doesn't matter. Sorry.
We just mentioned it, your lordship. Sorry. Now let's see the other judgment. Volume 8, page 3414, PDF 307. In the meantime, you find out, huh?
Page?
Page 3414, Manoj. PDF 307. Para 90, Malad, at 30.
3114.
Para 90 is at the bottom of the page. Another principle which this, I'm sorry, my lords have that?
Para 90.
Nice. Another principle which this court has repeatedly laid down for cases in which two constructions may be reasonably possible is that it should adopt one which harmonizes rather than one which produces a conflict between constitutional provisions. Precisely the argument of the other side. You want to create a conflict. No justiciability. I can withhold. That's my power. And I can withhold for as long as I like. Courts, para 91. Courts have been advised to adopt the construction code, which will ensure smooth and harmonious working of the Constitution. I'm sorry, Mr. Justice Suryakant. I'm sorry. It was para 90?
Yes, 91.
Yes.
Courts have been
Courts
advised
have been advised to adopt the construction code, which will ensure smooth and harmonious working of the Constitution, and
Yes, Madam
eschew the other, which will lead to absurdity or give rise to practical inconvenience. Mullah, this is exceptionally important. Or make well-established provisions of existing law nugatory. Now see the consequence, mullahs. I'll now just to contextualize it. Governor says, I'm withholding the bill because I believe that it is unconstitutional for A, B, or C reasons. And the state passes it again. And he still withholds it. What's the solution?
But on the second occasion, we can't withhold it.
But if he doesn't, then?
Send it back only, then the legislature will pass it again, no?
Yes,
Correct.
yes. And he
Legislature
still withholds
decides.
it.
If he doesn't send it back, then.
Still withholds it.
there is no-
Then what happens? This is why these observations. What happens? If somebody files a petition, governor can't be made a party. Who will defend the governor? Let's not interpret the Constitution to make it unworkable. That's the argument. Under 361, governor cannot file an affidavit. Court cannot issue a mandamus. If he chooses to voluntarily appear, he may appear. You can't interpret constitutional provisions to make the Constitution unworkable. And the language will not matter. The objective should matter. It's a living document. As I said, it owes its genesis to history, but it owes its allegiance to the future. And you are the future, because you interpret it. Let's not fall into a trap where the governor becomes an impediment in the functioning of the Constitution. Therefore, mullahs, you'll have to say something. Somebody has given a timeline of 3 months. Don't give a timeline, but you still have to say. Vishas had not seen, there is no way that he can withhold if it's passed again. Then you come to deem to. Then you say the court cannot do this. If you create a problem, you will have no solution. If you seek to resolve a problem, not over a cup of coffee, but constitutionally, you will have a solution. Huh? That's it, Malaz. That's on the interpretation, that's it, Malaz. I don't want to, there's no point in troubling your lordship. Now, let's come back to my propositions, and if your lordship is right. Huh? It was Justice Ahmadi in S.R. Bomai. Well, as I was on my propositions, where we reached. I'm not going to repeat anything, Malaz, because what has been argued, I'm going to touch. Your Lordships always say, but you still repeat, Malaz, I won't repeat. So far, I have not.
Time will tell, huh?
Paragraph 9 of my submissions at page 896. Under Article 163, the governor must also exercise his functions and act on the aid and advice of the Council of Ministers, with the Chief Minister at the head. Like the President, the governor is, as a rule, a titular head. Article 163, however, creates a narrow exception for the governor. Under 163(1), the governor must act on the aid and advice of the Council of Ministers, except insofar as he is by or under this Constitution required to exercise his functions or any of them in his discretion. The words by and under this Constitution and required in 163(1) are crucial and mean that the power of the governor to act in his discretion must be expressly conferred by the Constitution, which is why I said yesterday 200, the concept of discretion is alien to 200. It's a constitutional obligation. The words by or under required, once a constitutional provision provides specifically for the exercise of such discretion, then the governor's determination that a matter falls within his discretionary power is final and cannot be questioned on the ground that he ought or ought not to have acted in his discretion. Except for these provisions, the governor must act on the aid and advice of the Council of Ministers. The position is enunciated in Nabam Rebia. Now, Maharaj, I will not read the passages that Dr. Singhvi read, Maharaj, but I'll read some other passages. Kindly come to volume 22, page 8578. Can you give it to me? PDF 144, paragraph 87. 87.
Page number?
Page number 8578. PDF page 144, paragraph 87. The exact argument that was made by the learned solicitor about discretion under 163(1) and 2 was the exact argument made on behalf of the governor by 3 counsel and rejected. Now see Muller's para 87. It was urged that insofar as the present controversy is concerned, a correct understanding of 163(2), this is the argument of the governor in that case, would be of extreme relevance. Under 163(2), according to learned counsel, governor has the authority to act on his own. Same argument. In respect of matters where the governor is mandated to act in his own discretion by or under the Constitution. It was further submitted that when a question arises as to whether such discretion is vested with the governor by or under the Constitution, the decision of the governor on the above question is final and binding. It was submitted that 163(2) postulates 3 situations, whereas an exception to the general rule, the governor can act on his own will and discretion. Firstly, when he is required to discharge his functions by the mandate of some provisions of the Constitution itself, in his own discretion. Secondly, when the governor assigned functions on the basis of enactments made under the Constitution, where he is mandated to discharge his functions by exercising his own discretion. And thirdly, where he is impliedly required to act at his own discretion. Justice Narasimha mentioned that to me yesterday. This is the very argument, Mullahs, that was made in Nabam. Now kindly come to paragraph 89.1. 8579. PDF 145. Mullahs, that was the first time in the history of this court that a dismissed government was put back through a mandamus. Because the governor's action was found to be completely unconstitutional. He chose to summon the House on his own. He chose to fix the agenda of.
Kalyan Singh was also put back by court order.
Sorry, Mullah?
Kalyan Singh,
Yes. Kalyan Singh, yes.
97.
Ah, okay. Now see, Mullahs, 89.1. Mullahs, I'll start with just above placetum B. Herein again. Your Lordship has that?
89.1 you were reading?
89.1.
Yes.
That's just above placetum B. Herein again it was
Yes, sir.
submitted that the governor would have no role except to the extent contemplated under Article 200. See, Mullah, the 200 argument was also made. Wherein when a bill is passed by the House, the same has to be approved by the governor. And only when the governor gives his assent, the same assumes the status of a legislative enactment. It was pointed out that 200 contemplates a situation where the governor can return the bill with a message requiring the House to reconsider the same by examining the suggestions made by the governor. This limited responsibility cast on the governor, it was contended, fell within the legislative process. Argument rejected. The governor before whom a bill passed by the Legislative Assembly is placed has also the right to reserve the bill for the consideration of the President. This action of the governor, according to counsel, must be accepted as the further responsibility of the governor within the legislative process. It was submitted that all the functions vested with the governor under 200 are to be discharged by the governor in his independent discretion and not on any guidance or advice. This, according to learned counsel, illustrates the third category of governor's functions, wherein the governor is impliedly required to act in his own discretion, even though he is not expressly so required by any written mandate emerging from Article 200. Rejected. C99. Page 8586. PGF 152. Paragraph 99, Mullah, if I may.
Paragraph 99.
99. On the issue of discretion, the learned senior counsel placed reliance on 163(2). Based thereon, it was submitted that the governor's discretion for all intents and purposes must be deemed to be final. It was submitted that since 163(2) itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, by itself absolves the governor from a challenge to the discretion exercised by him. Precisely the argument. It was submitted that 163(2) was neither a defunct nor a redundant provision, and as such it could neither be overlooked nor ignored. It was contended that the words employed in 163(2) must be given due weightage. If that was to be done, there could be no doubt that the discretion exercised by the governor under 163(2) would have to be considered in a manner as would protect him from the scope of any challenge. These are the contentions. Now I tell you, rejected. 147 and 149, if I remember.
Paragraph 147.
147.1, I think. 1 point, yes. Actually, it starts from starts at page 8617. So that's 147.2. 1. The executive functioning of states is provided under Part 6,
Paragraph?
para 147.1. Well, just come, let's skip I need not read the entire paragraph. Kindly read between placetum D and E. Starting, Manoj, the question that will need determination at our hands. Your Lordship has that? Between D and E. The question that will need determination at our hands is whether the underlying cardinal principle with reference to discretionary power is to be traced to 163.1 or from 163.2.
Where are you reading?
Whereas between D and E, 147.1, starting, the question that will need determination.
Yes,
Lordship has that?
yes.
At our hands, is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from 163.1 or 163.2. Whilst it was the contention of learned counsel appellants that the same is expressed in clause 1 of 163, the contention on behalf of respondents was that the amplitude of discretionary power of the governor is evinced and manifested in clause 2 of 163. Undoubtedly, all executive functions of the governor of a state are expressed in the name of the governor under 166. That, however, does not per se add to the functions of the powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites, remissions, or punishments, or to suspend, remit, or commute sentences. Governor's power under 161 is undisputedly exercised on the aid and advice of council of ministers. The governor has power to frame rules for convenient transaction of business. The instant responsibility is also discharged on aid and advice. All in all, it is apparent the governor is not assigned any significant role in the executive functioning of the state. We therefore endeavor to examine the duties and responsibilities of the governor, and then, Malaj, para 148 at 18618, PDF 184. That's the final conclusion. 148. The above position, Lordship has that? The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as was assigned to him a dominant position.
Which is that paragraph?
148.
8618.
8619. Yeah.
8618.
18, not. Continues over page. Right, yeah.
I continued over the.
Yeah.
148?
148. I just read that. That really answers everything. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions that would assign to him a dominant position over the state executive and the state legislature. The interpretation placed under 163.2 on behalf of the respondents has just that effect because of the following contentions advanced on behalf of respondents. Firstly, whenever a question arises whether he is discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision postulates that the decision of the governor in his discretion shall be final and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondent, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above proposition will convert the governor into an all-pervading super-constitutional authority, which Dr. Singhvi read. But it was important to read to go to the alap Malats before we came to the conclusion. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions clearly brings out that the governor has not been assigned any significant role either in the executive or in the legislative functioning of the state. That position adopted in behalf of the Samad. So this Malaj rules out any possibility, and this is a constitution bench. Well, that's all reflected in my propositions. So I'm not going to read them, Mullah. Why waste time with your lordships, Mullah? Now,
149 refers.
Mullah,
to
there's also 154.
What?
154.
149 refers
Yes,
to
149.
constitutional debates and
Correct.
Dr.
Correct.
Ambedkar's,
Correct. That also. Your lordship is absolutely accepting the approach. And then, yes, all that will, Ambedkar is quoted and all that. Mullah. And then it comes to one.
these debates were already.
Yes, therefore, Mullah, I'm not going to take. Then come to 154.
622.
No, page 8622, Mullah's PDF 188. But just above 154, Mullah, just 5 lines above the previous paragraph, it is therefore clear, that is placetum, just above placetum B, A and B, the sentence, it is therefore clear. It is therefore clear that even though the governor may be authorized to exercise some functions under different provisions of the Constitution, the same are required to be exercised only on the basis of aid and advice tendered by, under 163, unless the governor has been expressly authorized by or under the constitutional provisions to discharge the function concerned in his own discretion. Mullahs, this is why I said in the opening, Mullahs, 200 is not one such provision. It's a constitutional obligation. You give him discretion, the Constitution will break down.
You gave yesterday, for example, 371A1B,
Yes,
where the discretion is.
exactly. A1, H, 371. And that way the executive field, it's an issue of law and order. Mullahs, even there, the discretion is qua law and maintaining law and order. It is not with reference to any legislation. Even that discretion, Mullahs. Because otherwise he is to be guided by the advice of the council under 371A, Mullahs. There is a Hills Council, there are councils, Mullahs. So he may differ with that advice. And then if he differs that advice, that discretion is final in respect of law and order. Again, nothing to do with legislation. It can't be, Mullahs. It will be contrary to all principles of constitutional law if you start giving the governor that power. We're not going to have to find a solution, Mullahs. I come to that later. But first, let's be clear on the constitutional framework. We'll come to the solution in a while. So then it says, Mullahs, it is therefore clear that even though the governor may be authorized to exercise some functions, this is between A and B at page 8622, under the different provisions of the Constitution, the same are required to, I've read that. Then 154, we therefore, of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides, not by implication, expressly so provides that the governor should act in his own discretion, which is 371A, etc. Additionally, a governor can exercise his functions on his own discretion. Additionally, on own discretion in situations where an interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of respondents that the governor has the freedom to determine when and which situation he should take a decision in his own discretion without the aid and advice of the Council of Ministers, Chief Minister and Council of Ministers. We accordingly also turned down the contention that whenever the governor in the discharge of his functions takes a decision in his own discretion, the same would be final and binding and beyond judicial review. We are of the view that the finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion as are permissible within the framework of 163(1). And additionally, in situations where the clear intent underlying a constitutional provision so requires, where the exercise of such powers and the aid and advice would run contrary to the constitutional scheme or would be contradictory in terms. So, Mullahs, this clarifies many of the things, Mullahs, that have been contending on the other side. Now, Mullahs, my submissions. Para 14, yes. Now, Mullahs, another provision which I think my learned colleague, Mr. Kaul, referred to, which I think is also important, 167 of the Constitution. There are two provisions that are important for your lordships to consider, 158 and 167. first 158. The governor shall not be, my lords have that. The governor shall not be a member of either House of Parliament or of a House of the Legislature of the state specified. The reason why he is given a position is because he is to act for the well-being of the state, which is why he is included in that in the provisions of the Constitution. Because he is acting on the well-being of the state. But he has no legislative role. Just that news. I just wanted to invite your lordship's attention. Now 167. My learned friend Mr. Cole referred to it. Rightly so, according to me. And this is where the hub will lie, Manas. Yeah, Manas?
Yes.
Yes. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the council of ministers relating to administration of affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposals of legislation as the governor may call for. And if the governor so requires, submit for the consideration of the council any matter on which a decision has been taken by a minister, but which has not been considered by the council. So, Maharaj, this is a pre-legislative process exercise, which gives you an indication of the contours of the power if it's to be exercised under 200. Well, that's why your lordship sees so often, and your lordship knows, every time the prime minister will go and brief the president as to what has happened. If he goes on a trip, he'll come back and brief him. If there are any proposals, he'll come back and brief him. There are, one nation, one election, he'll go to the president that, this is what we're contemplating. President may, in that informal discussion, this is Q 167, you have another provision, the same provision under the union. He will, have a So that's where the cup of tea happens, mothers. Not later. Exactly.
Not a cup of tea between your CM and the PM.
Yes. So this is where all the cobwebs are cleared. Once the cobwebs are cleared and the bill is sent to him, there is no occasion for him to say no. You have to work it out, Manas. We have to work out the scheme. So that's where, Manas, that conversation takes place. And then when the bill is sent to him, Manas, then he cannot say, I know I'm not going to accept it. I'll wait for 1, 2, 3, 4, 5 years.
From both sides. Right. Except.
We don't permit constitutional
Right.
authorities to
I've done that, Manas. Yes, I've done that. Yes. I remember Maharaj S.V. Gupte was the Attorney General at that time as a young man, maybe 28, 29. And I briefed him in a matter and we were in outside court number 1. And the matter was reaching and he was smoking Maharaj. And I said to him, Maharaj, matter is reaching. He said, yeah, it's all right. And it almost reached. He said, you go. You argue. This is the kind of seniors we had. Now you want to take over even what the junior argues.
Therefore, we have stopped mentioning in the.
Now serious
So
compulsory
glad.
orders.
I am so delighted, Maharaj. That's the right thing to do.
Yes, I will.
Why should senior appear in vacations?
Yes, correct.
You should have this thing.
There is, in my court.
Practice procedure, Maharaj, should not appear in vacations. Anyway, that's another matter. I'll get into trouble with that.
Seniors need to get more disciplined now.
Today only, I think you have exhausted all your 3 terms.
More or less. I'm going to, well, as I said, within,
You are exhausted all your 3 terms.
oh yes, of course, that, of course.
You
Yeah.
don't have to bother about that.
No, but Maharaj, one is bothered for the institution. All kinds of things happen, Maharaj. Suddenly you find that your case is reaching somewhere else, so you stop the argument. This is not what. Anyway, that's another matter.
Yes.
Kindly come to Maharaj, back my volume 2.5. So Maharaj, I was at, yes, I've already argued that what is there, Maharaj. I'm going to read it.
You're done?
I've argued, no, not yet. No, I will finish within the 4 hours given to me. Maharaj, I'll try and in fact give more time to others because there's no point repeating things.
Mr. Sibyl?
4 hours.
No, this says 3 hours.
That I don't know. I can finish in 3, no issue. I have no problems for us. And let us kindly come now to paragraph. I've done paragraph 15, 16. Then you come, I've also done 17, 18, Naban Rebia. I've read all that. Then page 899, 21. Declare, I've already done that. I've already done it. Well, let's not take the time of the court. Practice, Maharaj. If counsel do not sit in constitution bench matters throughout, they will be heard last. Then make them sit, Maharaj. Sorry, Maharaj.
Then by that analogy, Mr. Gopal Subramanian should have been the first one.
I'm ready. No, but we sat all throughout, Maharaj. We were there throughout. It's only
But
some comfort break occasionally, Maharaj.
in between you going out for some time, but
No, Maharaj.
sometime yes, we have seen.
Only to get the matter adjourned of that sort of pro bono matter.
But you took some 5-minute or 10-minute intervals.
Yes, but he's been throughout
He
here,
has been from morning to evening.
which
he
is
has-
why I've parted with Maharaj, the state.
And glued to the seat right from morning to evening.
Yes. And that's been our practice more or less, Maharaj. Now, sir, I've done declare issue, Maharaj. I've already indicated what that means. Then Maharaj 356. 356 is completely irrelevant to this issue. Because 356, again, as I told your lordships earlier, the only power of the governor under the Constitution is either to accept what the legislature says or recommend. There is no third power of the governor. Under any provision. 356, he recommends. On what basis? On basis of satisfaction. Question of satisfaction is subject to judicial review, but not the judicial review that we contemplate qua administrative action. That's limited. He has taken irrelevant considerations into account. That doesn't apply to 200. 200 doesn't deal with either satisfaction or discretion. So those arguments, those submissions that they made under 356 have no relevance. On 161 pardon, again, it doesn't apply. And on 311.2, just see Malas 311.2. That's the other area. There are only 3 areas and all recommendation. 311.2.
You read it yesterday?
I didn't. 311.2 I didn't read.
No.
I mentioned it, I didn't read it. 111 I read, not 311. If you see 311 and you see, Malas, the proviso to subsection 2, subarticle 2. It says, I'm sorry, Malas, provided that where it is proposed that after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making a representation on the penalty proposed. Provided further that this clause shall not apply to come to B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded. So that's the other area. See that where the president of the case is satisfied. So both 356 and 3112 proviso deal with satisfaction.
Subject to satisfaction.
Yes, not relevant as far as 200 is concerned. So all this is recommendatory. Governor has no power. So either you comply with the legislation as proposed to you, or you recommend. Send it back, a recommendation. Send it to the president, a recommendation. No power. If you read into that a power, it will be contrary to this entire constitutional scheme. Similar as that's on para 2022. Then 200 I have done. I have also mentioned shall not assent to Malas in 200, second proviso, where the powers of the High Court. And my Lord, the Chief Justice said that is clear that shall not assent to is different from withholding assent, where the constitution makers want it. So that is at para 24, Malas. I won't read it. That's already, huh? You want me to just read it? All right, 23 and 24 minutes, I will read on instructions. As such, the governor at page 900. As such, the governor has no discretion under Article 200. The issue of para 23 at page 900.
Page 900.
Page 900, para 23.
And 900.
Yes, at 900. As such, the governor has no discretion under Article 200. The issue of discretion does not arise under Article 200. The provision imposes on the governor a constitutional duty to act in many of the 3 courses of action: assent, return, or reserve based on the nature of the bill presented to him. These are not discretionary choices, but constitutionally mandated routes. Now, how they are to be operated, we'll deal with it. The issue of whether the governor is to send the bill back or reserve it for the consideration of the president on aid and advice of the council of ministers is immaterial, as the governor is not vested with the power to take any final decision on the bill, except assent to it. As seen above, the power to withhold is only recommendatory. If the governor believes amendments are required, he may return the bill for reconsideration, but once the legislature sends it back, he shall not withhold assent therefrom. But the argument is he can still withhold dissent, and further, that he can send it again to the president. It can't be done. There is no choice. But once the legislature sends it back, he shall not withhold assent. There is no choice. Likewise, if a bill derogates from the powers of the High Court, governor shall not assent, but must reserve it for the president's consideration. In neither situation is the governor exercising discretion. He's only following the mandate of 200. Regarding the first proviso, 200 as separate from the substantive part creates an absurdity regarding money bills. That's something that your lordships mentioned. That if he can withhold assent, he can also withhold assent on the money bill, because that's part of the proviso. But that will be an anomalous situation. So, therefore, I'll skip this, Mullahs. Then Article 200 cannot be read in a manner to create constitutional impasses and litigation between constitutional functionaries. You can't interpret the Constitution in a manner that will create more litigation. But personally, I think that 361 has not been accurately or constitutionally interpreted in the context in which it should be read. Otherwise, Balaj, you'll make 200 unworkable completely. The sequitur of giving governor the power to reject a bill will inevitably lead to litigation between the state legislature and the governor, as it has, embroiling the executive and the legislature in protracted conflict, thereby paralyzing governance and defeating the spirit of parliamentary democracy. Conjured facts have no relevance to the issue at hand, Mullah. All these facts that my learned friend mentioned, if he deals with foreign affairs, if the legislature deals, these are all conjured facts. And your lordship should not even look at it. You will decide a matter which is before you, not in the area of any situation which is a chimera, which has no relevance to reality, and you just conjure up something. I mean, legislatures, if you say the governor acts on the presumption that he is the highest executive authority and therefore acts with responsibility, the same assumption must be made in the case of the legislature, that they are acting with responsibility. Then, Malaj, in conclusion, para 29, in conclusion, an interpretation that gives the governor the executive power to withhold assent upends the entire constitutional scheme. The union's argument of separating the substantive part of 200 from the proviso allows the governor to avoid communication, bypassing reasoning, and ignore the primacy of the legislature, all while acting on his own and being immune from judicial review. This creates a one-time, first-instance veto, which is free from any kind of accountability. Such an interpretation builds a super-constitutional office wholly incompatible with constitutionalism, responsible government, and democracy. Then, Malaj, comes the timeline issue now. So, no more than 6 months, within 3 months, forthwith. Now it's the architecture that you create, which will be the law. And according to me, the following. All this confabulation must happen before the bill is proposed. Any problem that he has, and I'm giving a solution, any problem that he has must be communicated before. And once the bill is sent to him, he must assent. Right. There may be an extraordinary situation that may happen. I'll accept that there may be some situation where he still feels that he refers it to the president. Fine. But as soon as possible, forthwith must apply to the governor, must also apply to the president, because the president acts on the aid and advice of the Council of Ministers. So it's the government of India. It's not the president. So the same, what should I say, necessity of incorporating the concept of immediacy must be engrafted in the action of the president once the bill is sent to him, for he has to send it back. And if it's passed again, he can't say no. That's how the Constitution will work. Otherwise, it won't work.
There is a qualitative difference in Article 201 later part.
I know.
As against the earlier
Correct.
article.
Correct.
It shall be presented to the president.
For consideration. But it doesn't matter, let's convey the government of India.
No, I'm saying that he must grant assent is what you're saying.
No, true, but I'm saying that. Supposing your lordships were to say he need not grant assent, you create the problem. Well, ultimately, you will have to decide how it works. Let's assume your lordship's thinking, let's take it forward. That he keeps it with himself. He doesn't respond at all. So the will of the sovereign legislature.
Founding. They are talking about a solution. Are we saying that the Constitution compels that bills need to be assented?
Yes. Yes, absolutely.
like that unless.
Yes.
or else
No,
it
no, I agree. That's my constitutional premise.
Doesn't contemplate a situation.
Yes,
Where a legislature passes a bill.
yes.
And it is not assented to.
By the executive.
President, we are talking
The
about.
president is the executive. Maharaj. Because he acts on the aid and advice of council.
Analysis. From the legislature, it goes to the governor.
Yes,
It could go back to the legislature.
yes,
Then it comes back to the governor. Then first hurdle is that after that he can't refer it to the
Correct.
president. That's what, after he can't refer to the president. That also we need to find the textual requirement for that. And if it is permissible for him to send it, or even in the first instance, then the president considers, that's it. Constitutional text doesn't say that after his consideration.
correct.
Why is it that specifically it is chosen? So therefore, as a court, we need to supply those words.
Yes, yes.
Saying
Yes,
that the president has no option but to assent.
correct.
You want us to supply this?
Yes, yes, absolutely. Because that's the entire constitution.
In the context of the larger principle of
Yes.
parliamentary
Absolutely,
democracy,
absolutely.
federalism and separation.
Absolutely, absolutely. But the consequences would be disastrous. Point is, you are now a Hobson's choice.
So the constitution has not contemplated a situation where under the federalism, the union can not assent to a bill.
Yes.
To stop.
Yes. They will be challenged if ultimately, and you, lordships will decide whether it was right or wrong. But he cannot say no. That's the only way the constitution will work. Won't work otherwise. It's the same. The same. But point is, that's what I said.
11.
Exactly the same. So you can't have two different yardsticks. Otherwise, what happens, Malaj? The executive exercises a power to overrule the will of the people, whether it's in the state or parliament.
No, but Mr. Simple, 111 end and 201 end are different. They are not the same.
Shall not withhold a
No, then it is only sent for his consideration. What does that mean?
But naturally, Malaj, I'll tell your lordship. Your lordship is right.
Why it could have been said the same
Malaj,
language as 111?
if it shall not withhold assent as far as 111 is concerned, will you read into the constitution that he can withhold assent?
That's what we're trying to find out.
Malaj, therefore,
Why the language is differently used?
Malaj, because nobody ever, when they framed the constitution, imagined that this would happen. It has not happened till 2022. Since 1950, it has not happened till 2022. This issue has not come up before. So you should not intervene.
Yes.
Well, ultimately, your lordships will, let's assume now that the fact that it says it for the consideration of the president, there is an element of space within the government of India can say no. Let's accept that. What's the consequence? Litigation. So to that extent, the bill will never see the light of day till it is decided up to this court. Does the Constitution contemplate a situation like that? It's the question your lordships will have to ask. And if it does, fine, Mullah. I only think it will create a lot of litigation for us.
Good for the bar.
Good for the bar. Correct. Very sad for the people of India. Good.
Not good for the country.
I mean, constitutional provisions can't be interpreted in this fashion, according to me. It's a living document. It has energy. It has vivaciousness. Deals with situations that we see today cropping up, problems of governance, which we have never seen before. You have to resolve it constitutionally, not over cups of tea. Yeah.
Just last question. Proviso, the earlier question, when it goes back
Yes.
from the governor to the assembly, and
Yeah.
the assembly sends it back.
Yes.
The second stage, what is there in the constitutional text to prevent the governor from referring it to the president?
Yeah.
First, from the text of the theoretically
Yes,
or,
first.
or a principle,
Yes.
larger value of the democracy, is
Right.
all right.
Right.
But from the text, is there anything
Correct.
that when it comes back to him after his message, what is there in the text to prevent him from not referring to the president?
The text says he has to accept it.
When it comes back,
It says, shall not withhold assent therefrom. Therefore, he cannot withhold assent.
it doesn't say that it will have to be.
This is the only option. He has to withhold assent. He cannot withhold assent. That's what the Constitution
The
says.
later part you're saying. You're saying for the reason that the governor shall.
Reconsider the bill accordingly, and if the bill is passed again, with or without amendment and
You're
presented to the
saying that the
government.
later portion will give the meaning.
Yes, yes, exactly. Right. Therefore, Maharaj, as far as the governor is concerned, he has to clear it. As far as the government of India is concerned, they need not clear it. Both are executive, Maharaj. No, it's difficult to contemplate that situation constitutionally. So the proposition has to be, he has to clear it. There is an element of immediacy, must be done forthwith. As soon as possible means if it's impossible, that impossibility cannot happen in a constitutionally run regime. There can be no impossibility in dealing with the bill. So must be forthwith, not even 3 months, forthwith. There's an immediacy to the will of a sovereign legislature. And if he doesn't do it, Maharaj, you will have to then, Maharaj, create an architecture for making sure that the will of the people is represented through the legal process. The will of the people can't be subject to executive whims and fancies. Yes, there's a very